Professor Weber talked a little while ago about the inherent value of diversity in Canada. So symbolically, we are going to explore that value in this next panel.
Bears on bijuralism at the Supreme Court, the dialogue in private law between the common law and the civil law, pursued in French and in English, that is at the core of this court's identity. Il est souvent dit que la Cour suprême du Canada est la seule cour de dernière instance qui est formellement bilingue et bijuridique, qui oblige la Cour à travailler dans les 4 langues du droit, du moins langues officielles du droit au Canada, la common law en anglais, en français, le droit civil en
French, English, and common law, and civil law in both languages, as I say. So we see the 9 seats here behind me. We have, on one day you will have a civil lawsuit, and then it'll be common law 2 days later. So this is the theme we're going to talk about now, bijuralism. I have the honor to introduce our moderator, Shauna von Praagh, who she is an auxiliary at the work for the court under the late Justice Brian Dixon. She is a full professor at the McGill Law Faculty. She is a model of bijuralism. I know that for a fact myself because we worked together, we taught together in teaching civil and common law courses. We did many things together, so she is very well equipped to moderate this panel this afternoon. So Professor von Praagh, please go ahead.
Merci beaucoup.
Thank you very much for that introduction. I want to add my own thanks to the Chief Justice. It's a real honor to be here this afternoon. As others have said, it's difficult to follow up from one panel to the next, or certainly to live up to those high standards, but certainly our panelists will keep us wide awake.
So I will start by introducing the 2 panelists and then saying a few things about what I'm doing here that is connected to the theme of bijuralism at the court and in Canada and of course in Canadian law. So to my immediate left, Justice Audrey Boctor is a judge of the Superior Court of Quebec in the District of Montreal, appointed recently in June 2024. Prior to her appointment, she was a partner at IMK in Montreal and worked in constitutional, administrative, civil, and commercial law. Audrey has taught civil procedure at the faculties of law at McGill and also at Université de Montréal, and was a law clerk to Chief Justice Beverly McLaughlin in 2005 to 2006. To my far left, Professor Lionel Smith, who holds the Professorship of Comparative Law at the University of Oxford. His research focus, in his words, I think, is on all aspects of, in quotes, unselfish behavior in civil and common law. Prior to his return to Oxford in 2024, he taught at the faculties of law at the University of Alberta and Cambridge University, and for 22 years as a colleague of mine at McGill. Lionel was a law clerk to Justice John Sapinka in 1990 to 1991. So I'm here as moderator wearing 2 hats. I hope you can see them.
The first hat I'm wearing is as a professor of students who are learning, starting in first year, non-contractual obligation in an integrated or bijural format. I have 25 years of experience in the classroom with a bijural approach, and I know that it is possible and even necessary, perhaps, though it's difficult, to integrate our two legal traditions in teaching and learning as well as research and writing.
Today is the one I wear as the person entrusted with reintroducing the Law Commission of Canada to the Canadian law and justice landscape. The LCC, la CDC, la Commission du droit du Canada,
So the LCC,
an independent agency committed to engaging the people of Canada in the ongoing and dynamic evolution of law. Now note in the name of the Law Commission that we hear law, le droit, not les lois or laws, and one might make the mistake of reading this as some kind of uniform law referred to in the title of the agency. But I think, as I say, that would be a big mistake. This is anything but bijural, right? To read this as anything but bijural, right? That we can't think about the Law Commission of Canada or law in Canada, and it is indeed impossible to lead and develop a federal law commission in Canada today without a commitment to the coexistence, flourishing, and evolution of our legal traditions, our Anglo-Canadian common law inheritance, our Quebec civil law inheritance, and of course, Indigenous legal traditions in this land. So in this session, I extend an invitation to our presenters to share highlights of the ongoing story and evolution of bijuralism in the jurisprudence of the Supreme Court of Canada in particular. They will reflect on what Supreme Court judgments have demonstrated about the ways in which Anglo-Canadian common law and Quebec civil law live side by side, interact always with each other, develop along tradition-specific and yet permeable paths, and enrich our understanding of both substance and methodology in the domain of private law in Canada, and indeed beyond that domain. They will share insights and critical questions that will underscore the unique trajectory of bijuralism at the court and more broadly in this country. I expect we will learn that the dialogue between traditions is not always clear or smooth or even constructive, but that it is always fascinating, important, and woven into the identity of Canadian law, justice, and society. Each of our panelists will speak for 15 minutes, and then in response to a couple of questions that they actually have seen in advance, we will follow that with a little dialogue, and note, not a dialogue between traditions. So again, it would be a mistake here to think that one is going to represent one tradition and the other tradition, or dans une langue puis l'autre dans l'autre.
or in one language and then the other. But we're going to have a dialogue between these jurists from the academic point of view, especially in Lionel's case. Talking about judges and judgments in Canada.
To Lionel.
To begin with, I want to thank the members of the court for inviting me to participate in this wonderful symposium. This is certainly a subject important.
For 18 years before that council, and I had occasion to come to this court on a few times. and I was always facing this way. And I can tell you that this is much more intimidating. Je vais faire la grande majorité de ma présentation.
Most of my presentation will be in French and a little bit in English at the end. So please take advantage of the interpretation. I want to talk about dialogues, which I think are important to keep in mind that it's a plural. The word dialogue means an exchange of views between two or more people. It also means a discussion among people who are partners or rivals, political or otherwise, to try to come to an agreement. So each does not adopt the other's point of view fully, but I think that when we talk about private law in the Supreme Court, we need a dialogue to come to proper decisions. But this isn't always the case, as already mentioned. We are not principally looking at the history of bijuralism, but I think we need to spend a few minutes taking a historical perspective so that we better understand the present and can look toward the future. When the court was created in 1875, it was responsible for law across Canada, but Mr. Justice Baudouin actually took a unidirectional approach, and it was really more of a monologue than a dialogue. Civil law, of course, is special in that it is mainly in French. A common law takes place mainly in English across the other provinces, and common law was already used in Quebec since public law was based on common law, even in Quebec, as an example. And I will go back to the Lower Canada Code, which indicates that as indicated by Mr. Justice Taschereau in the Canadian Pacific Railway versus the Queen, that the decision would have been made differently if civil law was applied instead of common law. So there were two key factors. First, the Supreme Court interpreted the civil law as a statute and not as a code. And then second, since the solutions or the resolution would be the same if either were applied, then they usually applied simply the common law. But it was a profound shock that there could be different answers to the same question in depending on which type of law was applied. And so in Ottawa West, there was a decision.
Is there any less disfavored by law than it is in England? Dans Lister versus McCarthy, à savoir, permettrait une réclamation de la part de l'époux pour la perte de service de l'épouse. Le juge Judson constate, notwithstanding the so-called emancipation of women, such a elsewhere, and it is inconceivable that the rights of a husband in Quebec would be more restricted than those in the common law. Plusieurs attribuera à la nomination du juge Mignot en 1918.
So in 1918, there was a change because Quebec judges became more numerous on the Supreme Court, and it seems that respectfully they took the respectful approach of suggesting that there had to be a change to include a civil law approach. Civil and common law contain similar rules, but there has to be an interpretation based on the rules applied in civil law if that system is used. So some jurists compared the two types, the two systems, but others felt that a different system, a different interpretive system was needed. There was a case in which the judge refused to allow damages to be claimed because the English system was being used, and this meant that certain fundamental values were not being respected. In 1996, it was reconfirmed that the Canadian Pacific judgment was in fact faulty because the proper principles hadn't been applied, and in light of the specificity of the Quebec system, the civil law system, then there needed to be acknowledgement of that system in the Supreme Court procedures. So we don't necessarily agree with everything that was said by the various justices, but the use of both systems by the Supreme Court certainly is something we agree on. In 1949, as we know, the Supreme Court took over from the Privy Council office as the final court of appeal, and this made it a uniquely Canadian institution. In 1976, the Quebec Charter of Human Rights made the civil code system apply in public law as well. There were implications that were both well known and less well known. The Quebec civil law was deemed not to be best interpreted on the basis of common law principles, but on its own history. There was no doubt that civil law had its own path, its own evolution, and when the new civil code came into effect in 1994, then the Supreme Court adopted the principle that both systems needed to be applied in good faith, that both systems were competent and applicable, and that there needed to be a dialogue. There was also a parallel evolution in bilingualism in the court. In modern jurisprudence and case law, then there are reflections of this. The dialogue allows us to explore analogous approaches and special procedures that should apply. For example, in the case of the railways, even if the civil law was applied, then a special approach had to be taken because common law may have come to the same conclusion, but the process would not be the end. So in the case of common law provinces, then the rules were interpreted differently. In some cases, the standards are different. In the Riom case, there was a strengthening of the distinction between the two systems and how they applied. In North, Justice McLaughlin indicated that the common law and the civil law didn't make any distinction in economic decisions, and that under civil law it was not the type of damages, but the source, whether it was negligence or other. So there were aspects that were common to the two systems, but in some cases the approach was different and the emphasis was different. Third, the dialogue can help with each system because lessons can be learned from the application of the other system, whether we're talking about the civil code or common law. The experience in the United States and in Quebec indicate that a good faith approach in a contractual situation can be taken into account usefully. Justice Dubé, and this was a bit outside the private law context, was indicated in a ruling that the values and rules in the system applied, and that both the charter and the civil system in Quebec were applicable. Justice Dubé in the Morgan Toller case indicated that fundamental values were respected, and although Quebec was the only province in which there were no summary procedures, then the result was the same for similar offenses. Across the country, it was determined that there were no difficulties in application for contractual case, that in English Canada, common law could be applied in an extended way, and that it was compatible with the civil law application in Quebec and in the United States when there were difficulties with contracts. In the Churchill Falls decision, with respect to good faith negotiations, the court indicated that contract law could use both systems.
And Lionel, I know, will speak to some of the ongoing discussions in cases like Callow. But in my view, on what there cannot persist any doubt is just how crucial bijuralism is to the fabric of the court. And to round out my remarks, the case that I think most illustrates this is actually not a private law case at all, but rather the reference re sections 5 and 6 of the Supreme Court Act. The reference raised two issues. The first was whether judges appointed to the three Quebec seats must be current as opposed to former members of the Barreau du Québec, the Quebec Court of Appeal, or the Superior Court of Quebec. And second, whether Parliament could enact legislation to specify this requirement, or whether the composition of the court itself had constitutional status. Without seeking to wade into the entire analysis and background of the case, I wish to highlight two passages. The first, regarding whether Section 6 requiring appointees to be current members of the bar or bench in Quebec, the majority wrote that the purpose of Section 6 is to ensure not only civil law training and experience on the court, but also to ensure that Quebec's distinct legal traditions and social values are represented on the court, thereby enhancing the confidence of the people of Quebec in the Supreme Court as the final arbiter of their rights. With respect to the constitutional status of the court's composition, the majority wrote that the central bargain that led to the creation of the Supreme Court in the first place was the guarantee that a significant proportion of the judges would be drawn from institutions linked to Quebec's civil law and culture. The objective of ensuring representation from Quebec's distinct juridical tradition remains no less compelling today and implicates the competence, legitimacy, and integrity of the court. In my view, it's only when juxtaposed with the history of bijuralism at the court that we can begin to appreciate just how significant this is. Whereas the court in 1875 and for roughly its first 50 to 75 years considered its role as apex court to be one of unifying the law, respect for the distinct legal traditions and legal culture of the civil law is now a linchpin of the court's legitimacy.
So with that, hold all of that in your and we'll turn to Lionel.
Thank you, Shauna, for your kind introduction, and thanks also to the court for its generous invitation to speak on this memorable occasion. I'm genuinely honored to be here to mark with all of you this important anniversary of this great Canadian institution. I thank in particular Mr. Justice Kassirer, who had the leading role in planning this panel on bijuralism at the Supreme Court of Canada. Before I start, I wanted to share one thought. I've learned a tremendous amount today, and I'm sure I'm going to learn a lot more before the day is over. The very first thing I learned, chronologically speaking, is that when it was my turn to get up here, everybody would be able to see whether or not my shoes were properly polished. So I hope they are. And I begin with a few words on bijuralism and comparative law more generally, and what they mean to me in my role as a legal scholar, and then to explain what light this may shed on how these ideas might be relevant to the work of our courts and of this court in particular. It's sometimes suggested, and not only by judges, that the role of the academic branch of the legal profession is to assist the courts in their work. The most profound reflection on this, in my view, is a 2007 text by Professor Ernest Weinrib entitled, "Can Law Survive Legal Education?" ? Like everything Ernie has ever written, it is profound and brilliant. He argues that the role of those of us who work in universities is to study, to teach, and to care for the intellectual inheritance of the peoples of the world. One part of that inheritance is law, which is why we study law in the universities. So the object of our study is the practice of law in the widest sense that comprehends legal institutions, legal doctrine, and interactions between legal actors. And he argues that if a disassociation arises between legal practice and legal scholarship, this may be problematic, but not because the function of scholarship is to assist practice, although if it does assist practice, so much the better for both sides. Rather, such a disassociation would be problematical precisely because the function of the university study of law is to study, teach, and reflect upon the actual practice of law. The problem, therefore, for Ernie with a disassociation between legal practice and legal scholarship is that legal scholarship might then have no object. it would be as if, he says, people in the zoology department were studying unicorns. Venons-en maintenant au cas particulier du droit comparé.
Let us talk now about comparative law. It is well known that comparative jurists can be obsessed by the definitions in their own domain. So I have always liked clear and simple definitions. As my former professor at the university indicated in 2002, we need to define comparative law as broadly as possible, because we are talking about a law that is not our national law. It is a comparison that is a means to knowledge for us. When we define comparative law so broadly, it is inevitable that we discover that it is an activity that may have various objectives, and it may be to look for a type of national law through case law or legislation.
We think that there can be a lot to learn from other legal systems. To mention only two examples, former Chief Justice McLaughlin and Madam Justice Claire Lheureux-Dubé both published reflections on how helpful comparative law can be in the development of the law to resolve disputes. Of course, the account that we have heard from Madam Justice Boctor reminds us that this employment of comparative law must always be carried out with sensitivity to and respect for the legal order that governs the dispute. But some judges are firmly opposed to such efforts, no matter how they may be carried out. In a debate on the use of foreign legal materials in U.S. courts, published in 2004, the text of Mr. Justice Richard Posner was entitled, "No Thanks, We Already Have Our Own Laws." Now, if, like me, you like comparative law, this is at least puzzling. Legal reasoning has multiple components. Among them is the concept of binding authority, either of legislation or of prior decisions, which of course involves interpretation, itself another component of legal reasoning. But where authority runs out, we turn to reason. I know very well that what makes a good legal argument is not necessarily the same as what makes a good argument in relation to baseball or theater. But I think reason is reason. Mon ancien et regretté collègue,
My former late colleague published a text in 1992 on the basis of comparative law. He said that comparative law is intimately linked to the vision that one has of law itself. The vision places national law at the center. That vision of comparative law is at the service of national law. It is not always easy, but there are other ways of seeing things. In conclusion, I would like to share a few reflections with you about the debate among Supreme Court justices in 2020. There was a difference of opinion between the majority and the dissenting judges. I won't get into the details of the case, but what interests me for the purposes of this discussion are the different attitudes to the use of comparative law in the decision-making process. The majority judges based themselves on civil law as opposed to the Ontario common law in coming to their decision. The dissenting justices were in agreement with the conclusion, but took a more restrictive approach. They felt that using comparative law in this case was unjustified. It was a long ruling, but I want to give you just one quote. The minority judges, Justice Brown, spoke for them and said that in order to maintain the distinctive character of each of the two systems in Canada, we need to follow through with the proper set of rules to draw the conclusion. On behalf of the majority, the justice indicated that common law and civil law are not the only relevant systems for the court's work, but there is an opportunity to establish a dialogue between them, and that gives the Supreme Court a benefit because it has this deep knowledge and can apply it in that way. These different visions were reflected in 2012 in a judgment after indicated that most elements of comparative law did apply. He proposed another way of looking at comparative law. Etymologically, to compare things is to put them together on an equal footing. And I will conclude with Mr. Justice Glenn's quote to say that a literal understanding of comparative law means that there are no underlying analogies to be made.
And if there are tendencies to drift apart, one continues to bring together. The process of comparison would thus in no way imply resulting uniformity. Indeed, if anything, it implies the reverse, that differences remain, which must somehow be brought together such that coexistence of difference is possible. That's the end of the quotation. On my first reading, I found this slightly puzzling as a goal of comparative law, as it is quite abstract. On reflection, it seems to me that this is because I myself tend to start from the centrality of national law, perhaps as an unstated axiom. But what Glenn is saying, it seems to me, is another way of talking about a dialogue between legal orders, because a dialogue presupposes equality, not hierarchy. Thank you.
Well, thank you to both of you, Lionel and Audrey, for your very rich and thoughtful and I think complementary kind of presentations that get this panel going. Note, as I was listening, I thought I would just underscore what I'm sure you all noted, but this from both the substance of what we just heard, but also the form. Right? This particular identity of Canada and Canadian law in which these two major legal traditions can be studied, practiced, talked about, and developed in two languages all the time, right? So that each one is as I say, developed and continued and enriched in both languages. And we just heard that and saw that encounter. So my broad first follow-up question has to do with the strengths and capacities of all of us as jurists in Canada and in other countries, but here with a focus on Canada. How would you articulate how those strengths and capacities can be associated with a plural approach to law and the integration, not meaning uniformity or harmonization, but coexistence of legal traditions? What potential comes with an openness to the insights, sources, vocabularies, and approaches of a legal tradition other than the one in which a particular claim is framed, or in which a particular judgment, for example, or on which a particular judgment is focused? And I think I'll just add on right away in this first question, how are those strengths or capacities, ces forces, potentiels, how are they particularly significant in imagining the integration of Indigenous legal traditions, this importance of understanding and working with the stories, the actors, the cultures, the languages that are unique to coexisting legal traditions in one territory? So I know there's lots that I have just thrown into that first kind of multi-part question. I think I'll turn to you first, Lionel, and then to Audrey.
Thank you. I'll start first maybe with a word about capacities. As I said earlier, comparative lawyers get very caught up in their own methodologies, and the extreme versions of this lead to people saying, who are themselves comparative lawyers, that comparative law is impossible, partly because they may think that since law is a creature of human society and is intimately connected to it, that you can't really understand another legal system unless you understand everything about that society. And you certainly can't do comparative law in translation. I personally find this a bit puzzling. I'm of another school that says just because you can't do something better than anyone else in the world doesn't mean you shouldn't try, and you might learn a lot, and you might get some very interesting insights that you might be able to share with others. But capacity in that sense can be limiting. I think you could be a comparative lawyer if you only spoke one language, but as soon as you speak two or three, you can probably get a lot more out of it. And the same goes for being trained in multiple legal systems, but that's a lot to ask. So it's a challenge, bijuralism and just like bilingualism. And if we go to tri or multi, then it's much more challenging, of course. On the second part of your question about Indigenous law, I think all I'll say about that is that the dialogue part of it, perhaps a very multilateral dialogue, becomes much more important. I'm a sort of universitaire of my generation, and it leads me to a kind of way of looking at the world that if I want to learn something about German property law, I'm going to go sit in the library and read some books and I'll learn about it. But Indigenous legal traditions are not like that, and there is no way to integrate them, I think, into our system except through a different kind of process, which is going to be very multilateral. And very, I mentioned dialogue requires equality, and it has to be a dialogue, obviously, of that kind. That goes without saying.
I guess I will start with the second part of the question first. And I think actually that there are a lot of lessons that can be learned from the history of bijuralism at the court that can be you apply to the future. And to build on what Lionel was just saying, I think that what the history of bijuralism at the Supreme Court shows us is that genuine dialogue requires equality, respect, and mutual confidence. And I think the second thing is that genuine dialogue happens not just because you need to have it, but because you want to have it. And I think when we look at many of the cases in which the Supreme Court has done a fantastic job of establishing these kind of universalities, universal values, we've looked all around the world, but we haven't looked at Indigenous legal traditions. The third thing I would say that we can learn from the history of bijuralism at the court is that representativity and legitimacy do go hand in hand. And finally, that, again, genuine dialogue means being open to adapting based on what you've learned. So if I go back now to the first part of the question, I think, it's a bit hard for me to answer this question because I grew up as a child of McGill Law, and so I learned the law from day one as a comparative exercise. We started by talking about the legal traditions, and then it was every class in first-year law school was taught from a comparative perspective, all the private law courses. And so to me, this is just a normal way of thinking about things. And so as counsel, it was a normal part of my practice. I always looked across the country at what was going on because it helped me to understand better, because I thought it would make what I was arguing more relatable. I think there's a big persuasion, a persuasive force that comes along with being able to say, well, here's the answer that I'm proposing, and look, here's these other reasonable people who agree with what I'm offering you. And I think also what the comparative exercise allows is as we were talking about, is this attempt to find what is universal. And just as Albie Sachs said that universality isn't globalism, well, universality isn't uniformity. And so I think the comparative exercise it helps us as a tool of understanding and also as a tool of persuasion. I think if you want to persuade someone, you need to understand how they think, and you need to be able to speak in terms that with which they're the most familiar. And so I think especially when it comes to litigating cases in this court, I was always of the view that presenting the case in a way that reaches all 9 judges as opposed to just a subset, even though everyone is very well versed in both legal traditions, was an asset. And I also want to say that I think it's I guess probably a bit trite to say that when the Supreme Court speaks, the Supreme Court speaks to the whole country, no matter where the case comes from. And so if I go back to the example of Hereniak versus Malden, which is the big decision that the Supreme Court rendered, which was about the rules of civil procedure in Ontario, about the rule of summary judgment. And as I mentioned, Justice Karakatsanis takes the time to go through all the different provincial rules, and she even notes that Quebec doesn't have summary judgment, but has analogous types of procedures to try to get at the same goal. Well, that case has been cited hundreds of times in Quebec for the proposal of the basic importance of proportionality and the need for a shift in culture in the legal system. So that's...
Merci.
I think that I'm going to push you a little further. I would like you to speak just a little bit more about the factors or the pathways that are important to nourish and encourage dialogue and cooperation in promoting the evolution of the two systems and comparative law in Canada. I think you've broached this a little bit already, but how do you see the possibilities, perhaps, in educating the magistrature, the justices, or even including the Supreme Court? Where are the spaces? How do we strengthen these spaces for interaction between our two legal systems and those that work in it. You said that you studied at McGill, and of course, it's hard to take that hat off. So to understand what legal education would be like without the integration of the two systems. I think that I think you can also be adopted into an integrative approach by creating a bijural approach. Audrey, perhaps you could go first? I think that there are different approaches, as Lionel said. I think being able to speak more than one language is very important. And to be a bijural country, if we really want to engage in a dialogue between the two systems, it is a huge asset to be that we have both official languages used in our judgments of the Supreme Court. They are all in both languages, and we can learn about the two systems and languages in the meantime. This reflects the importance of education at all levels. I talked about education in both legal systems, and of course we need to learn about Indigenous traditions. It would be a mistake to think that we can be a legal expert in Canada without having any knowledge of the other legal system. We have federal legislation passed in both official languages that integrate the concept of harmonization with the provinces and their legislation, where these laws are going to actually be implemented. So I think that there is basic training needed in both systems, and this is something that we need to give more serious thought to. I also think that training in Indigenous law traditions is important as well. Certain bar societies have started down this path, and it's something that the bar associations and judges also need to take seriously. Thank you. Lionel.
Bilingual legislation reminds me of a kind of paradox that I've sometimes described, particularly in my new home in England, where people often don't know very much about Canada. The paradox, as it seems to me, is that federal legislation, like Quebec legislation and that of some other provinces, is required to be bilingual, constitutionally required to be bilingual. And you might think by the light of nature that this is so that people can have access to this legislation and read it and understand it, even if they only speak one of the two official languages. At least that's what I would assume lies behind these constitutional requirements. But of course, when the Supreme Court of Canada had to face the question of what is the right way to interpret this legislation, it concluded, if I can summarize in a very perhaps featureless way, that you have to try to find the common meaning between the two texts, the two languages, which must be right. But of course, the paradox is, to understand the legislation, you actually have to be bilingual, even though we think it's bilingual so that you can understand it without being bilingual. Does that make sense? Am I the only one who thinks that's kind of weird? So why do I tell that story? Well, the problem of competence is illustrated in a way by that, right? In the name of not needing people to be bilingual, we're now saying you sort of need to be bilingual. But coming back more directly to your question, I think I'd say, there are spaces and opportunities. I think it's largely driven by what people want in terms of their own intellectual capital. Are they interested to learn about the other legal system or not? And if they are, I think they can, whether they're practicing lawyers or judges or still law students. It's true that this may be harder in some places than others, and it's the phenomenon that I was getting at in my introduction, that people may have an unstated axiom that the local law, the national law, if I can put it that way, is everything, and everything else is somehow the other. That starts in law school, or it doesn't start in law school. That's my view, and it reminds me of the famous line of Albert Einstein that what common sense is the collection of prejudices that you have when you reach the age of 18. There are things that you absorb, and if you absorb them in that way, it's very hard to get past them. But I think it's possible. So those are my thoughts on that. Thank you.
Thank you. Alors, je vais poser une question.
I'd also like to ask another question. How has bijuralism influenced the structure and the writing of judgments? Are Supreme Court judgments perfect in terms of bijuralism and that approach? And I want to add a little something to that. Could we say, or do I dare say, that the Supreme Court should just agree to hear a private law case if it is significant for the entire country? That is, that it is significant for more than one law tradition. So I would like to hear what you think that means for the Supreme Court's work. Lionel can start.
For
judgments, I think that there are a lot of people here in the room who are better positioned to answer that question than someone like me. I have always thought, and maybe this doesn't directly answer the question, but I've always thought that, I think it was Chief Justice Dixon who revolutionized the way judgments were organized. And certainly it was an improvement, and it made the rulings more accessible, easier to access. I never thought, though, that bijuralism imposed an additional requirement on a judgment, because a judgment is something that needs to be well organized, it needs to be well written, regardless of whether it's bijural or not.
The second part first. So I don't think that the remember that the requirement is not national interest anymore, it's public interest. And so I don't think that such a requirement would be, I think when, I think about cases in particular that come from civil law, and I'll preface this with a caveat that I had occasion to argue a few private law cases before this court. One in which I advocated for an expansive view of good faith and lost, and another in which I argued for a more restrictive view of good faith and lost. So, but the point being that in both those cases, I think if the requirement were to show the importance across the country, I'm not sure that the cases would necessarily make their way to the Supreme Court. And I think that there are fundamental questions in Quebec civil law that certainly have impact. They have impact because the principles, the principles are shared. And as I mentioned before, whenever the Supreme Court speaks, it's speaking to the whole country. But I don't think a requirement that, especially in private law cases, that it be of interest to outside of Quebec would be a good requirement. On the first part of the question regarding the structure of judgments, I'm not sure that there is really a perfect way to do it, and I'm not sure that we would also want to impose a recipe of exactly when and how we need to take, we need to do a bijural exercise. I think it happens where it's enlightening and where it's instructive and where it serves one of the purposes of comparative law, but it doesn't necessarily need to happen in every single case. So I think, even though one might say that it's a bit uneven and we're not sure when the Supreme Court's going to do a kind of a more bijural look at a question and when it isn't, what I would say is that for anyone appearing before the court, it's never a bad idea to come prepared, for that, because I think there is a real interest in understanding how legal solutions are going to impact the entire country, even if a case emanates from one single province. And so I think it would be, part of anyone's preparation coming to the court to prepare for those questions from the bench, to be able to answer, the tough questions about the kind of the fundamental principles that are shared and how the decision one is asking the court to make is going to impact that.
Thank you. So for the last question, I'm going to combine a few things that I'm seeing on the screen as questions. One, and both will give you an opportunity to engage in that very nice challenge that we find particularly in private law in both common law and civil law traditions, and that's foreseeability. So a little bit of prophesying, if you like, here. But one question that kind of expresses a little bit of a concern of kind of the insistence on coexistence of legal traditions in Canada. Can we insist too much? And does that threaten in some way or damage in some way a commitment to some unity? That's the word used in the question, a kind of a unity aspect of Canada. And then, so kind of looking ahead and thinking about that, perhaps tying it to some of the things that we've heard in other panels today. And the other piece of this kind of, how, as we insist on referring to and recognizing and learning about a panoply of coexisting Indigenous legal traditions in Canada, will that enrich dialogue between common law and civil law, or is it likely that we'll kind of shift into a common law, Indigenous law comparison on one hand and a civil droit civil, Indigenous law comparison on the other, that might be somewhat disappointing, if you like, in terms of ongoing kind of enrichment of the exchange among existing legal traditions that continues to evolve. So you can choose various. I don't. There are lots of pieces in there, but in your putting your foreseeability hat on, what are some of the challenges that you hear in those questions or comments, and how might we kind of imagine moving forward? So, Audrey, I think you're first.
I was going to say, please go ahead.
I saw that. But,
I'm not in charge here.
I think there's always we can always have a concern of as you say, is it too much at a certain point? Is it if we just do it for form, and if it's not genuine, does it risk doing more damage? And I think as Naomi was mentioning too, is there a risk of things, if it hasn't been properly brought before the court, by counsel with a rich understanding of the legal tradition in question, is there a risk of misinterpretation or of kind of a surface treatment of something that's actually quite a bit more complex? So I think there are certainly always risks there, but I think it doesn't mean we don't try to get started in some way. And I think as Naomi was discussing, kind of if there's a parallel development of an articulation of Indigenous legal traditions that comes from Indigenous peoples that the court can draw from and learn from, that's obviously preferable to the court having trying to do it all on its own.
It's very interesting. If you think of my example of the title of Judge Posner's participation in that debate, I think some people feel a little bit threatened, perhaps, by the suggestion that they would be better lawyers if they knew more about other legal systems. That maybe they think that's sort of changing the rules after they've complied with one set of rules. But it may simply just be the suggestion that there's still a heck of a lot to learn. Some people find that, I think, exciting. I remember when I first started, I guess, becoming a comparative lawyer many years ago, and learning more and more civil law, finding it very exciting, and it was like climbing to the top of a hill and seeing a whole valley stretching out. You can do private law in a whole new way. There's more law to learn. I was so excited. But I guess, maybe that's something very particular about me, and not everybody thinks that it's exciting that there's more law to learn, if I can just put it that way. So it can feel threatening, I think, to people personally, but then there's also the aspect that people may see it as potentially threatening to the integrity of one or both of the two legal orders that we're talking primarily about, not only about. And I don't know whether that's still a concern. Obviously, it has rightly been in the story that we heard. It was rightly a concern of civilians in Quebec that there are some Privy Council cases, I think, as well as some Supreme Court cases, which didn't seem to think that it was important to pay attention to the way, the logic, if I can put it that way, of the civil law. But if we're past that, and I think we must be if we're talking in terms of bijuralism, then I don't see that as a major concern, but that's maybe those are just my own prejudices coming up again.
Well, I think we will leave it there. I think as we're listening, je pense que vous avez tous les deux souligné.
I think that we will take as two of your more important points the importance of training. There are always things to learn. It's not just to add more detail from respective legal systems, but actually to enrich our own system with what we learn. In Canada, sometimes the interactions are difficult, but we do have two coexisting legal systems.
Really integrated, but integrated in our history and in this kind of foreseeability sense in our future. So merci à nos deux.
Thank you to our two speakers this afternoon, therefore.
Et en effet, grand merci à nos
Very big thank you to our two panelists for their remarks on juralism and the Supreme Court.
court allowing jurists to move effortlessly between the common law and the civil law in French and in English. You've obviously got that down to your very great credit. So I'd ask colleagues here to join me in renewing our thanks to Professors von Praagh and Smith and to Justice Boctor for a wonderfully dialogic session.